Hello, this is Matt on the Moon Lambeau channel, and here it is from attorney James K. Filan, member of the XRP community. Ripple defendants file motion to compel regarding the SEC's deficient responses to Ripple defendants' fourth set of requests for admission. So basically, Team Ripple, their lawyers, just seeking to get an agreement on just basic facts and circumstances, which is very normal in court, I've come to learn. And it's just part of the process. You know, it could be something very simple. So there could be a lot of requests for admission, including the car that hit my client was blue. It could be something as innocuous as that. And so it's really just trying to make sure that both sides agree on obvious facts that aren't debatable in particular, so that you can move forward. There's less confusion once you get to trial. It may make certain discovery not even necessary from what I understand. But here you have the SEC refusing to play ball. If I'm the judge, I'm getting kind of furious at this point because, I mean, the SEC's refusing to say if speeches on its website are accurate. It's completely absurd. So I'm going to share with you analysis from John Deaton, from attorney Jeremy Hogan, and also from John Deaton's crypto law organization. Plenty to unpack here, and it is infuriating. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, you'll see as we go through this, part of what the SEC is claiming is so absurd that they can't be doing anything other than just being, it's like a child throwing a tantrum. Like they're just trying to be difficult. And that's why I'm saying, if I'm the judge, I don't fall for this stuff. I've got a perfect example when we get a little bit further. So here's analysis from John Deaton's crypto law organization that was shared on Twitter. I want to read some of this to you here. Check this out. Motion from Ripple, Brad Garlinghouse, and Chris Larson to compel the SEC to provide responses that eliminate the need to prove facts about which there is no real dispute. So, folks, that's what I was saying. The SEC is making this difficult. It's just facts are facts, whether you like them or not. It doesn't matter. And the SEC is refusing to admit facts because it seems to not like certain facts. That's what it looks like to me. So check this out. SEC document production so far has included at least 57 unique inquiries submitted over a period of more than 29 months, asking the SEC whether it considered XRP a security, and the SEC always responded it, quote, had not made a determination, end quote, as late as October of 2020. Ripple sought to confirm the undisputed fact that the SEC was asked multiple times by market participants and never stated XRP was a security to any of those inquiries, but the SEC refused, saying that market participants is vague and ambiguous. So there you go. The SEC clearly, like, they've never told anybody publicly that they don't find XRP. Well, their official position is that they, to this point, they hadn't come to an actual declaration. At least the closest we've gotten to that is when they sued Ripple, claiming that XRP at that point is an unregistered security. But their claim, and they've stated this in the past, it's up to the court to decide that. So even though they're making the determination, it's up to the court. And so again, they're refusing to acknowledge that they were asked multiple times by market participants what the status of XRP was legally. Was it a security? Was it not a security? They won't even answer that question, even though clearly, and we know this, I've brought up examples on my channel, we know market participants have asked the SEC, what is XRP? Is it a security? Is it not a security? And so they're saying, well, market participants, what the hell do you mean by that? That's what they're arguing. They say it's vague and ambiguous. Oh, really? Market participants, that's a vague and ambiguous term. Well, funny thing here, as it turns out, I have the internet, and I got the Googles, and so I typed into the Googles, what is a market participant? And you know what popped right on up? Is a website of the federal government, investor.gov. And this was written by the U.S. Securities and Exchange Commission. They have a whole page here explaining from the SEC themselves what market participants are. I kid you, it's on your screen right now. Market participants, look what the SEC wrote. Part of the mission of the SEC is to maintain standards for fair, orderly, and efficient markets. To do this, the SEC regulates a number of securities market participants. These include, and then they listed a bunch of them. So the SEC has declared on a federal website what market participants are, yet when that term is used in this case, the SEC's claiming that the term market participants is vague and ambiguous, even though they have a whole page about it. Completely unreal, right? The goal of these people. That's what I'm saying. If I'm the judge, at some point, I'm starting to get a little bit angry. You know what I'm saying here? John Dean's crypto law continues. The SEC added it lacks sufficient information to answer that Ripple request despite it being directly about communications that go to and from the SEC. Can you believe this? The audacity of these folks. Well, we can't answer that. Insufficient information to answer that. Bitch, it's your damn communications that we're talking about here. Yes, you can answer this. It's just so laughable. And then John Deaton's crypto law continues. The SEC was also caught in double talk about when XRP first appeared on its watch list, first telling the court it was April 13th, 2018, then denying it later, then claiming prior statements were in error and refusing to clarify. That sounds exactly like the SEC, doesn't it? Also, we see that Chris Larson made a presentation about XRP in October of 2013 to the SEC, U.S. Treasury, Federal Reserve, FDIC, FinCEN, IRS, and FBI, and many other agencies. But the SEC refuses to answer any request for information from the defendants about that presentation. Little defiant there, don't you think, folks? Completely. This is not how adults behave, my friend. This is not how adults. This is a child throwing a tantrum. But I don't want the facts to be the real facts. It hurts our case against Ripple. Shut up, you little bitch ass. Freaking asshats working at an asshatter. I ain't got no damn time for that. Then John Dean's crypto law continues, and they wrote, the SEC has also refused to even affirm it never issued a no action letter on any digital asset before April of 2019 because the phrases relating or pertaining to a digital asset are vague and ambiguous. There it is again. The word relating, it's too vague, it's too ambiguous, pertaining to a digital asset, even though you know what it means. Anything having to do with the digital asset, right? You know that's what that means, because you got a freaking brain. You're listening to this, you got a brain. You got a pulse, you know what it means. But that's vague and ambiguous, says the asshats over at the SEC. Well played, you little pricks. And then crypto law continues and states, the motion lays bare to the judge how illogical and legally indefensible the SEC's evasion has become and reflects the confusion XRP holders suffer in the face of no clear rules, no level playing field, and regulation by enforcement. Well, ain't that the truth? Now, here's what attorney Jeremy Hogan had to say on this. This motion to compel by Ripple is really an XRP de force of its fair notice affirmative defense. And although it's always a good idea to get the other side before passing judgment, this motion makes me think that the judge is going to grant the motion as to every category. Ooh, I wouldn't mind that one bit. Then he continues, a request for admission reduces the burden of litigation for the parties in court. If the SEC admits that Chair Clayton gave a certain speech, and the transcript of the speech is accurate, Ripple now doesn't have to subpoena him to trial just to prove that was indeed his speech. Here, remarkably, the SEC won't even concede that certain speeches were made and that the transcripts on their own website are accurate transcripts of the speeches. Talk about obfuscation, my friends. It's on their damn website, these assets. They refuse to answer a question about data that they put on their own damn website. Oh my God, this is just infuriating here. And then Jeremy Hogan says, this failure by SEC counsel wastes time, money, and resources. And here, the objection that market participant is ambiguous and therefore the SEC cannot answer the request smells like the type of gamesmanship that will get you in trouble in court. Let's see the SEC response, but I wouldn't want to be the attorney drafting that one. That's for damn sure. And then there was this, there's something was highlighted in this filing from Ripple that I'm citing. An individual from the community named Ashley wrote the following. Here, I'll just make this screen grab full screen so those of you looking at your television or whatever device you're using can see what I'm talking about if you care to. But here's what was written by Ashley. OMG, Ripple launches veiled threat to subpoena Amy Starr, Hester Peirce, Bill Hinman, Jay Clayton, and Robert Jackson if the SEC fails to confirm public statements made by them. This is getting juicy. Yeah, and so obviously, like I said, the SEC, they're just being a bunch of adult children here, throwing a tantrum because they don't want the facts to be the facts, that the facts they harm the SEC case, help Ripple's position. And so here you can see what they actually wrote. It's what's highlighted in yellow, which reads as follows. It is far less expensive and burdensome for the SEC to undertake this inquiry for the limited purpose of confirming that a recording is authentic than for defendants to be forced to subpoena these individuals. Damn straight. Attorney John Deaton saw that, also retweeted it, and wrote the following. If I were a judge, I would look at the SEC with serious anger. These particular requests for admissions only ask for the SEC to admit that these are statements of Clayton, Hinman, Jackson, and Hester Peirce. It doesn't require the SEC to admit that the statements are relevant. So again, SEC just being a petulant child, effectively. That's what's happening here. Really grinds my gears, folks, but that's what's going on. I don't see how they get away with this. I don't see how the SEC really walks away with a win. I mean, unless you count the settlement with some sort of cash award from Ripple, if you want to consider that a win. But in terms of things going, Ripple being able to move forward, XRP being able to be traded in the United States, all that stuff coming back, that still would be a massive win for Ripple, really, and XRP holders. So in those terms, I don't see how the SEC gets the type of win that it initially sought to achieve. I don't see how there's a path forward for them. The facts and circumstances aren't on their side. And they seem to get that, which is why they're trying to deny reality. You don't know what a market participant is? Oh my God, it's on your freaking website. All right, I'm done. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.